Good afternoon. My name is Lisa Gingeleskie, and today's presentation is Social Media in the Workplace. Today we'll be talking about best practices for employer use of social media during the hiring process. We'll also be discussing additional issues, including employee discipline involving social media posts and employer policy governing social media in the workplace. There are many benefits to using social media in the hiring process. It can enable employers to gather information that's useful in making their hiring decisions. For example, it can identify potential candidates by advertising online, and it also enables employers to learn more about the interests of prospective employees. For example, a prospective employee may list affiliations with professional groups on his or her LinkedIn profile, any civil or social organizations, accreditations, degrees, licenses, etc. Using social media also enables an employer to identify that prospective employee's professional qualifications and skills. For example, an employer may be able to gauge a prospective employee's written communication skills by reading his or her professional blog or referencing speaking engagements. Gathering this information is very valuable to an employer, and it provides them with many benefits that enable that employer to determine whether or not that candidate is qualified and fit for the position. While all of these things are very helpful to an employer, it's important for employers to be aware of certain legal pitfalls. Those legal pitfalls include anti-discrimination and lawful off-duty conduct laws, the Fair Credit and Reporting Act, and password protection laws. And we're going to be discussing each of those areas of law shortly. As most of you are aware, federal, state, and local laws prohibit discrimination in hiring based on a prospective employee's protected class. So what does that mean? When an employer goes online and it gathers information that it may determine, that helps it to determine whether or not a prospective employee is the right candidate for the job, it cannot use any information that is considered protective status to make the determination on whether or not to hire that individual. And the case I have cited to you here is Gaskell versus University of Kentucky. It's the last bullet point on the slide. And I'm going to spend a few minutes discussing Gaskell because it's a great example of how using protected information can come back and bite you as an employer. Gaskell is a case where the court looked to whether a top candidate was passed over partially because the employer discovered information about the candidate's religious beliefs through an online search. Gaskell applied for the position of the director of the University of Kentucky's McAdam Observatory and was not hired. Instead, the university hired a former student and employee of the university's Department of Physics and Astronomy. Although the university conceded that Gaskell had more education and experience, it argued that it hired the other candidate because he demonstrated more of the qualities that the university wanted in its observatory director. Turns out that during the search process, one of the committee members discovered Gaskell's personal website, and that website referenced certain religious topics, including articles that questioned the theory of evolution and contained Gaskell's own statements which blended religious and scientific thought. This information was circulated to the search committee, who, as members of the scientific community, expressed concerns over these statements. In the end, the search committee recommended another candidate for the position. The court ultimately found that there was a genuine issue of fact as to whether religion was a motivating factor in its decision to not hire Gaskell. So Gaskell is a great example of how viewing a prospective employee's social media during the hiring process can reveal information about his or her protected status, like religious belief, for example, and how use of that information can serve as a basis for legal actions against an employer. So as we just discussed, Gaskell is a great example of how anti-discrimination laws can serve as potential liability for an employer. I want to bring you to two other points of discussion. One being that employers who use targeted advertising to post a job on social media may create an appearance of discrimination against a non-targeted group. For example, a lot of companies will advertise for new or recent graduates, which generally results in a pool of candidates that are overwhelmingly in their 20s. There's an argument, however, that this is targeted advertising, and that targeted advertising may deter older candidates from applying for that position. While there's no specific case on this topic yet, it's important to realize that deterring an older candidate from the position based on targeted advertising may serve as a basis for an age discrimination suit. Likewise, making a hiring decision based on the lack of social media presence may implicate age discrimination. So, for example, if you as an employer are considering certain candidates for a position and you're looking online to gather information in order to make an informed decision about a particular candidate, and you notice that they don't have a social media presence, they don't have a Facebook account, they don't have a LinkedIn account, and you aren't able to gather the information you're looking for. Based on that, if you make a decision not to hire that person, it could ultimately come back as an age discrimination claim. Of course, the exception to that is when social media is an essential part of the job. For example, if you are Facebook and you're looking to hire an individual and that person doesn't have a Facebook account, they're not using the product, and that would serve as a reasonable basis for not extending an offer to that person. So while there are so many benefits to using social media during the hiring process, it's very important for you as an employer to be mindful of what information you are using and how you're going about using that information. As employers, everyone is familiar with background checks and credit checks. A lot of times you utilize providers that offer services to provide these background or credit checks to you as an employer. There's something very similar to this with respect to social media, and these providers are aptly called third-party social media background check providers. Just like traditional background and credit checks, employers can use the services of these third parties to provide social media background checks. And what these providers do is they gather information regarding a prospective employee, gather online information regarding a prospective employee. However, before providing the results of their search to the employer, they must redact any information regarding a prospective employee's protected class status. Now, this can be very helpful because any protected class information is never provided to the employer, and this can certainly help to insulate an employer from future discrimination lawsuits. While using a third-party provider can be very beneficial to the employer, employers need to be aware that third-party providers are considered consumer reporting agencies under the Fair Credit Reporting Act. Therefore, social media background check companies must comply with all Fair Credit Reporting Act regulations. These requirements include notifying the employee that the employer may obtain a consumer report and obtaining written consent from that prospective employee before even going about obtaining that report. So any employers out there who are currently using a third-party background check provider, please make sure that you're complying with all Fair Credit Reporting Act requirements, including those requirements if adverse action is taken. And what do I mean by that? For example, if you do utilize a third-party background check provider and they provide you with information, a report on a prospective employee, and based upon that report, you decide not to hire that individual. Under the Fair Credit Reporting Act, that prospective employee or candidate is entitled to a copy of the report as well as a right to dispute the contents of the report. So it's just very important for you as an employer to be aware of the requirements under the Fair Credit Reporting Act should you decide to use a third-party and media background check provider. These standard forms are generally available through the Trade Commission website, and our office provides these forms to our clients as well based on their specific industries or needs. Either way, you as an employer need to ensure compliance. Another important area of the law that employers need to be aware of when using social media during the hiring process are password protection laws. Several states have recently enacted laws addressing employer access to current and prospective employee social media accounts. These laws generally prohibit employers from requesting password and username information. However, depending on the state, these laws may protect more than just requesting username or password information. And New Jersey, of course, happens to be one of these states that has a broader password protection law. And New Jersey's law prohibits employers from asking or requiring that job applicants or current employees provide or disclose a username or password, or in any way provide the employer access to a personal account. Now, what does in any way provide the employer access to a personal account mean? It likely means that you can't ask an applicant to change the privacy setting on a restricted account to enable an employer to have access to it. That's pretty much common sense. But it likely goes as far as to restricting an employer from asking a potential applicant or a current employee to accept an employer's friend request online. That's going to be considered overreaching, and that's going to be considered an example of where an employer may be asking to have access to a personal or restricted account, and it could violate New Jersey's password protection law. It's important to know that this law is not without limitation. An employer can still access these accounts to conduct an investigation to ensure compliance with other laws, and of course, if there are any allegations that an employee is transferring proprietary or confidential information, they may then also have access to this personal website. But generally speaking, the password protection laws are pretty common sense. You as an employer should not ask for a username and password. Don't try to impose yourself into a restricted account. In the world where everyone is everyone's friend online, don't send friend requests to a potential applicant or even to an existing employee. You could run the risk of violating a privacy law as a result. So, what are the best practices you can take away from all of this? We talked about the benefits of hiring a third-party social media background check provider. If you do that, it's important that you comply with the Fair Credit Reporting Acts where applicable. I also have on here that it's a good idea to conduct social media searches at the end of the hiring process in conjunction with any background checks. Generally, when you are considering hiring someone, you obtain a pool of applicants. You assess that pool, you start to limit it down, you go over their qualifications, and then towards the end, you likely engage in a background check. It's a good idea to do the social media check at the exact same time. Again, as we talked about, don't make hiring decisions based on a prospective employee's lack of social media presence, unless, of course, that media presence is required for a position, because as we discussed, this could lead to an age discrimination claim. And last, I have on here that if you're performing social media background checks in-house, it's important to take extra precaution. And I'm going to talk about what that is. If you perform those checks in-house, they need to be performed by the Human Resources Department, and any protected information should not be shared with hiring managers. In fact, it's not just enough to not share that information. HR should document that hiring partners have not been given access to any of this information. Another good idea is to create a list of social media sites that will be searched for each prospective employee and to use the list to screen all prospective employees in a uniform way. Consistently use that list for each applicant. Only review publicly available information about a prospective employee, otherwise you're going to run the risk of violating a privacy law. And do not request username or password information or otherwise try to gain unauthorized access to private pages. Again, you could run the risk of violating a privacy law. This may sound like common sense, but please confirm that all the information you obtain actually belongs to the person in question and that it's not someone else with the same name. And of course, confirm that all the information that you gathered is accurate. Our next major topic that we're going to be discussing involves disciplining employees for social media posts and the National Labor Relations Act. The National Labor Relations Act, or the NLRA, is an act designed to protect the rights of employees and to encourage protective bargaining. The National Labor Relations Board is a board of individuals that was created to enforce the act. The board has been very active in recent years, and while historically it has played a bigger role in union activity, it has become much more active in non-union activity as well. So it's important to remember that the NLRA, the National Labor Relations Act, applies to all workers regardless of union affiliation. So what does the NLRA do? It protects employee rights. And I have here that it protects the rights to self-organize, to form, join, or assist unions, to collectively bargain, or to engage in other protected concerted activities. Now we're going to be talking about what protected concerted activity means, but for purposes of the slide, I wanted to let you know that these rights collectively are referred to as Employee Section 7 rights. Another important thing to know under the National Labor Relations Act is that regardless of intent, an employer commits a violation when engages in conduct that, quote, reasonably tends to interfere with the free exercise of employee rights, end of quote. Now, what reasonably tends to interfere with the free exercise of employee rights is a determination that's made by the board. It's going to be made on a case-by-case basis. It's very fact-sensitive. What we need to keep in mind before we look at the cases that address this language is that the current board views protected activity very broadly, and we're going to see examples of that in the upcoming slides. So the question is, what is protected concerted activity? Everyone has that crazy friend in the office who rants and raves. They're complaining about their workplace, they're complaining about their boss, they're complaining about colleagues, and a lot of times employees laugh it off. They think it's funny. They don't really think anything of it. However, these comments can impact the day-to-day operations of the employer. And when that happens, an employer is likely to take action to discipline the employee. But before they do that, they need to keep in mind and they need to know whether or not the activity in question is protected concerted activity. If it is, and the employer takes action, disciplinary action, they may be violating the NLRA. So, what is protected concerted activity? Concerted activity must involve a term or condition of employment. That includes wages, hours, or any host of topics that an employee would discuss with his or her colleagues. Concerted activity must occur for the group's mutual aid and protection, and it can include a group of employees, which is 2 or more individuals, or an individual acting on behalf of a group of employees. Now, I have 3 standards up here: the Myers Industry Standard, the Atlantic Steel Standard, and then the Electrical Workers Case, which is often referred to as the Jefferson Standard. I'm going to be speaking about each of these standards, but my primary focus is going to be the Myers Industry Standard. And that's because the Myers Industry Standard is the overall governing standard used by courts and the board to determine when an employee is engaging in protected concerted activity. Under this standard, when an employee is acting with or on the authority of other employees and not solely by and on behalf of the employee himself, he or she may be engaged in protected activity. And the board's going to take certain factors into consideration. Those factors include whether the employee discussed the social media post with any other employee, whether there were employee meetings or an attempt to initiate a group meeting regarding the subject matter of the post, whether the employee really sought to bring the group complaint to management's attention. Really, the focus is on whether the activity occurred for the group's benefit, not just for the individual employee. I have Atlantic Steel on here because it's a standard that the board may apply when the activity in question loses protection. And it loses protection when the subject matter rises to the level of outbursts or threats. And really, it's when an employee is complaining and directly threatening their employer as a result of that complaint. And again, the court is going to look at the place of discussion, the subject matter, the nature of the employee's outburst, and whether the conduct was provoked by an unfair labor practice. The Jefferson Standard, what I have here is the Electrical Workers Local 1229 case. That removes the protections of Section 7 where an employee makes disparaging or defamatory statements about an employer or its products or services to outsiders or third parties. And really what that means is when an employee disparages an employer's products or services to a client or to a customer, when it's essentially bad-mouthing the employer to that customer, it's that conduct is going to be entitled to less protection. And the courts are going to afford that conduct less protection. Below are 3 very recent instances where the court has used the Myers test, which, as I explained, sets forth the governing standard for determining whether the conduct in question is protected. And I'm going to spend some time talking about Hispanics United of Buffalo, because that involves a very broad interpretation of what constitutes protected concerted activity. And that has serious implications for you as employers. There, a coworker criticized another coworker's work performance. The coworker who was criticized took to Facebook to complain about her colleague, stating that her colleague, quote, feels that we don't help our clients enough. I about had it. My fellow coworkers, how do you feel? And that the employee who was criticized basically posted that on her Facebook account. 4 other employees responded to the Facebook post, maybe making comments such as, what the hell, what does she know? And when the employer found out about these postings, it fired all 5 of the employees for violating its anti-bullying policy. The board, in turn, found that the employee's termination was a violation of the NLRA. Why? The board said that the exchange did not constitute harassment and that the anti-bullying policy discouraged the exercise of employees' Section 7 rights. What's important to note here is the employees who were complaining about their colleague only did so on Facebook. They never met, for example, in the office cafeteria or even somewhere outside of their office to discuss their complaints or even had a conversation about bringing their complaints to management's attention. So even though that didn't take place, the board nonetheless inferred that the employees had contemplated group action. So what can we take away from this? The board is going to apply a very broad standard to what amounts to protected group activity. And that group activity does not have to be expressly stated. It's enough to be inferred, which is what the board did here in Hispanics United of Buffalo. What does that mean for you as employers? If you have an anti-harassment or anti-bullying policy in place, of course, enforce it. If the employee's conduct truly rises to the level of harassment. However, it's important to tread lightly if the conduct involves communications about terms and conditions of employment, and if the communications are merely considered unpleasant and embarrassing. Another important point to make is that it's important for you as employers to be sure that your anti-harassment policies and your anti-bullying policies are worded clearly to provide specific examples of what amounts to prohibited conduct. We deal with clients all the time who come to us with policies that are simply too broad, and they find themselves in trouble. It's important to have these policies in place that specifically provide examples of what constitutes prohibited conduct and to give that conduct context so employees know exactly what is prohibited conduct. The second case I have cited here is the Nose Motor case. And this case involves salespeople who are on commissions. So for those of you with employees that receive commissions, this is a case you may want to pay some attention to. There was a car dealership event. And some of the employees posted pictures on Facebook criticizing the food that was being served at the event. An employee who posted a picture of the food also posted a picture of a car accident that took place outside the dealership, mocking the employer. When the employer found out about these postings, they fired the employee. The board came back and said that the Facebook post regarding the food was protected because the salespeople were upset and concerned that the substandard food would affect their commissions. So again, the board is looking to whether or not there are any complaints about the terms or conditions of employment. Here, they're complaining about the food. They thought it could affect their commissions. Commissions are terms and conditions of employment, so it was deemed protected activity. However, the board said that the employer could rightfully fire the employee for posting the picture of the car accident because they said there was no protected activity here. The posting was simply a lark. They were simply making fun of the employer. There were no discussion of terms and conditions of employment. So on that basis, the employee was rightfully terminated. And last but not least, I have the California Institute of Technology case. And that is a case where the court specifically addressed the personal use of employer computers. There, an employer terminated a number of employees for sending mass emails from their work computers, criticizing a new policy that required exhaustive background checks. The board came back and said that the conduct was protected concerted activity because the employees were discussing working conditions. And the employees did not lose protection merely because they were communicating through the employer's computer system. So what can we take away from the California case? Employers can't inhibit employee communications involving terms and conditions of employment, even if it's taking place over your own computers as employers. The next case I have on here is the 3D case. And that is a case that is interesting because it specifically addressed whether or not a Facebook like can be construed as concerted activity under Section 7. There, what happened was a bartender was employed by Triple D, and he was upset over the restaurant owner's miscalculations of tax withholdings. He stated, quote, maybe someone should do the owners of Triple D a favor and buy it from them. They can't even do the tax paperwork correctly. End of quote. 2 other employees liked the post and commented, I owe too. Triple D had an internet blogging policy in place, and it prohibited employees from, among other things, engaging in inappropriate discussions about the company, management, and or coworkers. Triple D fired all 3 employees for violating this policy. The board reviewed the case and said that while the policy did not explicitly restrict the exercise of the employee's Section 7 rights, nonetheless, the employees could reasonably interpret the policy to prohibit protected activity, and therefore the policy was unlawful. So what can we take away from this? Any broad or general policy that prohibits employees from engaging in general terms like disrespectful, negative, inappropriate, rude conduct is going to be considered prohibitive because it's simply too broad. As I said before, you as employers need to have policies in place that are clear, that give context, and provide specific examples of what is considered inappropriate conduct. Another important thing to take away from this case is simply liking a Facebook page is going to be considered an expression of support, and it's going to rise to the level of protected concerted activity. Here, the employees didn't sit down at a lunch table, didn't sit down outside the office to discuss their frustrations with their employer. They simply posted on Facebook and they simply liked that post. That was enough to say that more than one person feels this way. And it was considered a group activity and therefore protected activity. So this is just another example of an expansive view of what is considered protected activity. So what is your exposure as an employer should you find yourself in violation of the National Labor Relations Act? You could be liable for a whole sort of things, including back pay, interest, damages, injunctive injunctive relief, all the things I have listed here on the slide. So what can you do as an employee to protect yourself from liability? If you don't have an employee handbook in place, please create one. If you don't have a social media policy in place, you need one. For those who have a handbook and policy in place, review it. Is it specific? Does it give context? Does it give specific examples? If not, it needs to be revised. The NLRB is so active in targeting employers who either willingly or unknowingly restrict protected behavior. It's a very hot issue right now. So employers need to be aware of how broadly activity is being interpreted and make sure to protect themselves. We talked a lot about what is considered protected activity. So what are examples of social media posts found not to be protected concerted activity? Under the National Labor Relations Act, Section 7 is not going to offer protection to individuals who are simply voicing personal gripes or complaints. Even if other employees benefit from it or have an interest in the subject matter, if it's just airing a complaint, it's not going to be afforded protection. And I have the Lee Enterprises case here as an example. There, an employee was working with a newspaper. He was a reporter for a newspaper. And he went about tweeting certain information considered unprofessional and inappropriate by his employer. And he also went as far as to linking the website page for the newspaper on his tweets. What were his tweets? His tweets consisted of criticizing the copy editors, criticizing a local television station, and various tweets about stories that he wasn't even responsible for reporting. The board came back and said that the employee's tweets did not involve protected activity because the tweets did not relate to terms and conditions of his employment, and the employee did not seek to involve other employees in issues related to this subject. So he was properly discharged. So again, what is the board looking to? Is this employee talking about terms and conditions of employment? If not, it's not likely going to be protected activity. If he is this individual acting on behalf of a group of employees? Again, if not, there's not going to be protected activity. The next case I have on here is a Walmart case. You can go ahead and read the posts that were made by this disgruntled employee who was clearly not happy with his manager. What happened here? This individual was ultimately fired for his posts, and the board came back and said that the posts were not protected activity, and because they didn't seek to initiate group activity. The employee's comments were simply his individual frustrations, and in fact, the coworkers who did respond to these posts said things like they found it funny, or asking why he was so wound up and offering him emotional support. They didn't imply that they agreed with him, that they wanted to engage in any sort of group activity or to bring this concern to management's attention. Therefore, he was properly terminated. So again, the board looked to whether or not there were terms and conditions of employment that were implicated and whether or not a group activity was involved. If not, it's not going to be protected activity. JT Porch Saloon, this is another case where the social media post was found not to be protected. And this was a case where there was an employer who was complaining on Facebook about his employer's tipping policy. And you can see what he posted. He was complaining he hadn't been given a raise, that he was doing waitresses' work, and he was also complaining about the customers themselves. His employer ultimately fired him for these complaints. The board found that there wasn't a violation because he didn't discuss any of these postings with his coworkers. In fact, none of his coworkers even responded to his postings. So the board viewed his postings as not an attempt to initiate group conduct, and it did not rise to the level of protected activity. So we're seeing a pattern here. If if the action is going to be considered protected activity, the employee must be talking about or involved in an activity that concerns a term or condition of employment, and the activity must be for the group's benefit or protection. If these two requirements are not met, there can be no violation of Section 7 rights. So to sum it up, I essentially am going to reiterate what I just said, is that the board is going to look to terms and conditions of employment and whether or not a group of employees or an individual working on behalf of a group of employees is involved with the activity. Personal complaints, gripes, if it doesn't mention terms and conditions of employment, that is not going to result in protected activity. What can we take away from all of this? Whether an employee's social media post constitutes protected activity is a highly fact-sensitive analysis. It's not easy to predict. It's going to be made on a case-by-case determination. So if an employer finds an employee's conduct offensive or unprofessional, before they take action, they need to consider the standards set forth in Myers, which is whether the employee is acting with or on behalf of a group of individuals or a group of employees, and consider the risks of litigation. In order to avoid litigation, to avoid liability, employers need to review their handbooks and policies. And if you don't have those handbooks and policies, to get them in place. We discussed the benefits of doing that. Another thing I want to mention, however, is how important it is to train management and supervisors on enforcing these policies, and to make sure that that training and the enforcement of those policies is consistently applied. So, for example, employees need to know what constitutes harassment, what steps need to be taken when a claim of harassment is presented, and to apply the policy consistently amongst all claims, amongst all employees. What amounts to protected activity is going to be made on a case-by-case basis. Right now, the board is taking a very broad position with respect to what amounts to protected conduct. And so it's just very important that you as an employer take the steps to protect yourself with your policies and your handbooks. At this time, for those of you registered to receive CLE or HRI credit for attendance in today's presentation, the code is 8090. So we discussed a little bit about what conduct amounts to protected conduct under the NLRA. We're going to take the next few slides to discuss what policies are considered permissible under the NLRA. And generally, a policy is impermissible when it explicitly violates Section 7 rights, or when an employee would reasonably construe the language to prohibit Section 7 rights. Reasonably construe is a very broad, open-ended interpretation. We're going to look again at case-by-case, fact-sensitive determination. The cases we discussed today give you a sense of what the court and the boards are allowing. So again, go to your policies and your handbooks and make sure that your policies are protecting you. I have examples of what policies are considered permissible and impermissible. Costco Wholesale Corp. Was a case where the board invalidated an employer's posting that prohibited employees from making statements that, quote, damage the company or damage any person's reputation. The board found that policy to be overly broad. They concluded that it could reasonably be interpreted to chill employees' exercise of the right to engage in protected concerted activity. Again, any sort of broad language that doesn't give context, that doesn't give specific examples, is going to be struck down as impermissible. Likewise, in the DirecTV case, there was a confidentiality rule that instructed employees to never discuss details about your job, company business, or work projects with anyone outside the company. This policy was considered unlawful. There, the board concluded it could reasonably be understood by employees to restrict the discussions of terms and conditions of employment, as well as limiting communications with union representatives. So it was instructing employees never to discuss basically anything with anyone, and clearly that restricts their ability to discuss terms and conditions of employment or to have productive conversations with union representatives, and it was struck down. Wirehouse Company is an interesting case because Wirehouse involved a company-wide policy that restricted electronic media use to business purposes and limited person activities was permissible. What does that mean? The policy there restricted internet use to business purposes only, but it allowed a limited personal use with the consent of the employee's supervising manager. That policy was considered lawful. However, what happened in that case is that the employees were using their work email system to communicate about contract matters. And when the company saw that these emails were going back and forth, they issued a statement that the union's use of these emails during work hours had risen to an unacceptable volume. The board came back and said, nah, you can't do that. They said the policy itself, while permissible, the notice that restricted the union workers' use was unlawful because it was specifically targeting the union workers. So Weyerhaeuser is a great example of a permissible policy with an impermissible application. Again, that is another reason why employers need to train their supervisors and managers about not only the policies themselves, but the application, and to to consistently apply the application of those policies to all employees. Quicken Loans is another example of what's considered permissible and impermissible. Quicken Loans, the first policy I have on here is think before you tweet or post or comment or pin. What you share can live forever. If it doesn't belong on the front page of the New York Times, don't put it online. Clearly, that policy is going to be considered too broad. It's just general language. It doesn't give context. It doesn't give examples. And it's going to be seen as limiting an employee's right to discuss in terms of conditions of employment, to initiate group action. It's simply going to be struck down as overbroad. However, I have two policies here that were considered lawful, and that's a personal electronic devices policy. And that stated that approval from management was necessary before any sensitive company information could be stored on a personal electronic device. And the amount of information stored should be kept to a minimum. It also discussed the transmission of sensitive information. The board is generally going to allow policies that require management approval, especially when it involves confidential information. But remember the application of that policy. It cannot restrict union workers only or certain sensitive information only. And again, that comes into play the importance of training management on the uniform application of all of these policies. So what is permissible and impermissible policies? Anything that's viewed as overly broad or vague or a blanket prohibition is going to be considered unlawful under Section 7. So, for example, any language that restricts posts to be completely accurate or not misleading are simply going to be too broad and ultimately prohibitive. In order to be permissible, policies need to be clear. They need to provide specific examples of prohibited conduct, and to just make sure that your managers and your supervisors are aware of what these policies are and to apply these policies uniformly amongst all employees. The last thing I want to bring to your attention is social media and harassment. This is a subject that could probably warrant a presentation on its own, but what I want to point out is that it's so important to include references to social media in your anti-harassment policies and any training that is offered to prevent workplace harassment. And again, make sure that the corporate response to harassment through social media is consistent with the response to harassment in other contexts. With respect to harassment, courts often afford a safe harbor to employers who regularly train their employees on what rises to harassment, the steps that are taken in response to a harassment claim, the investigation procedure, etc. Social media clearly plays a role in all of this, given the online world. Members of our labor and employment group in our offices regularly conduct training sessions for our clients to keep them abreast of changes in the law, not only in harassment and social media, but every area of employment law. Employment law is constantly changing, it's evolving, and it's important for you as an employer to stay on top of these changes and to conduct regular training sessions to ensure compliance with the law and to make sure that you're protected against any potential lawsuits. This concludes today's presentation. We will now look to see if we have any questions. Thank you.